You ready?
Yes.
Okay, let's bring them out.
Listen, I don't need Miss Kirby yelling at me because I messed something up.
No. You would not be doing that. Kirby might do that.
Kirby would mess it up, but I won't.
Yeah, but you would. Don't tell her I said that, though.
Did you talk to Kirby about that?
I addressed it last week, so she's on the.
Uh-oh. Next door? She left me to go see Judge Washington? Seriously?
No, and I can't.
Hold it, don't bring him out.
Want me to stop it?
Well, no, they brought him here. He can have a seat right there, because I'm not clear what's happening. Thank you. Well, to one of you. I'm still not forgetting that door thing. That'll stay with me a long time.
Yeah.
Constantly looking over my shoulder when I'm driving. She's looking nervous. Don't worry, you got this. Oh, goodness gracious. Everything was going fine, and then you don't need to read that. Miss Reiser had it all under control. Everybody was just fine.
Okay, what happened?
Nothing yet. Hold it.
Oh, no, you have to let the.
Oh, yeah. Oh, yeah, no. You just stepped in and she just sat down. That's not happening. She got all prepared. She was ready to roll. And then you came in. All right, good. It's about time.
Okay.
Court does call the case of the people of the state of Michigan versus Christian, is it Philip?
Leo Sinski on behalf of the people are requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Caitlin Kirby.
Did nothing, but Ms. Reiser did. Permission to practice is granted. Just wanted the record to reflect that.
Good morning, Your Honor. Rita White on behalf of Mr. Christian Phillip. And my P number is P63046.
All right. And what are we doing today?
We will be entering into a plea agreement with an added count 5 of attempted R&O, Act Code 750.81, with punishable up to 1 year and $1,000 fine. And the defendant will also plead guilty, or no contest, I'm sorry, to count 3 of DV. And upon the court's acceptance of a no contest.
He has to plead guilty for the 4A.
Yeah, he has to plead guilty for 4A, but may I approach, Your Honor?
Yes, please. Thank you. Oh, who wrote that?
Hey.
No, I'm just kidding. Kidding. Jeez. So sensitive. See that? See what Kirby's doing? She just around over. Just
Thank you, Mr. President.
don't leave us. No, okay. Okay, counsel, what you were indicating is that he will be pleading guilty to count 3 as stated, count 5, the added count 5 attempted R&O, the 1-year offense. Upon a successful plea, counts 1, 2, and 4 would be dismissed. Is that a correct statement?
Yes, Your Honor.
Is that a correct statement of the agreement?
Yes, Your Honor. However, with regards to count two, I am going to be making a referral to the mental health court for him to hopefully be eligible for diversion. However, I'm not sure if he would qualify or be able to make a plea under a plea period or a no contest plea if I am requesting referral for mental health court.
Hold on a second. On count two?
Yes, that will be reduced to attempt. So it's basically count two dismissed and modified to attempt.
Your Honor, it's an added count 5.
Yep.
That's what she's referring to.
Yeah, count 5 is being
All right.
dismissed, but it's being modified.
No,
One
no,
way or the other.
Count 2 is being dismissed, and added count 5 is what she's trying to get into mental health court.
Ah. And so, since we're really talking about the same thing, we're talking about the attempt or no.
Correct.
Correct.
You're looking for a referral to mental health court on that charge?
Yes.
I mean, usually the screening's done before the plea.
Correct.
So,
Correct, Your Honor.
so I don't know, does he? I mean, I would just be sending him over upon a successful plea to Judge Freshour for sentence. Now, I don't know whether or not after that she would accept or sign off on a referral to mental health. So I don't know what, because typically I don't do it that way either, but it's usually done beforehand.
Yeah, we would like it to the process to proceed because I am going to address mental health court diversion screening regardless. So in terms of which way your court handles it procedurally, we're good.
Well, it's not me that will be, I'm just saying, typically what happens is prior to the plea, and I realize different places do it differently, the referral is made, and then you know at the time that, yeah, that he's eligible and that he can go in, because that can guide a lot of different decisions.
Your Honor, if I may, we had talked about mental health court before, and we talked about a referral the last time we were here when we asked for an adjournment. And that referral would have been done in that amount of time with the screening. That being said, this is the second time that I brought my officers out. My one officer is the one that was injured. We did plan on proceeding with the felony today. So they do know that there is a chance that mental health court might not be an option if Judge Freshour says not, but we will be proceeding on a felony exam today if the defendant is not going to take the plea.
He would like to take the plea.
Okay, all right, very good. And we have, well, he can do it right there. Can you raise your right hand, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name for the record, please. You may put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to 2 charges. Is that your understanding? Yes. First charge is the stated count 3 of domestic violence. That is a misdemeanor. It's punishable by up to 93 days in jail and up to a $500 fine plus court costs. You understand that?
Yes, Your Honor.
The second charge is an added count 5 of attempted resisting and obstructing an officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty to these charges? Question mark.
I'm afraid I didn't get that question, so.
Okay. Understanding the maximum penalties, do you still wish to plead guilty to these charges?
Yes.
All right. To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty as well.
Now, you understand that by pleading guilty, you will not have a trial of any kind. Okay. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that? You understand you're giving up your right to appeal of right.
Can I talk to my lawyer, please? I'm afraid I'm not getting all this.
What is his? We don't have, it sounds friends. We don't have friends on the man, do we? All right, so you understand that you're giving up your right to appeal of right.
Yes,
All right. Are you on probation?
no,
Are you on parole? All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will? And because you believe that you're guilty of these offenses?
yes,
May 20th, 2023, at the location of 3480 Johnson Road, Saline Township, Washtenaw County, State of Michigan. What happened between you and Catalina Phillip that makes you think that you're guilty?
so, we were having arguments and a little bit of fighting, both of us, not only me. I pinched her.
You did what?
I pinched her.
You pinched her. Okay. So you were arguing, you were fighting, and then ultimately you pinched her? All right. Did she give you permission to do that?
We didn't talk about the mission before.
Okay.
Never happened.
Well,
No, so it's basically no, she didn't.
okay, and she didn't give you permission to pinch her at that time, did she?
No, she didn't.
And you did that on purpose?
I guess, I mean, yes,
Oh,
yes.
what do you mean you guess? I mean, it's really simple. Did you pinch her on accident or I don't,
No,
counsel, did you want to do the voir dire?
Yes.
Because please.
Okay, on the date and time that the judge did indicate, again, you were at the home of, the home in Saline that you and your wife reside in, correct?
correct,
Okay, and you had been involved in an argument with your wife, correct?
correct,
And throughout the course of this argument, as you indicated, you had pinched her, correct?
correct,
And during that pinch, you clearly you did not have permission to pinch her.
correct.
Okay, and so based on that, did you, in terms of you not having permission to pinch her, you indicated that you believe that she gave you permission, correct?
Correct.
Okay, however, it's fair to say that the police came to the home, correct? Okay, and it's true to say that you had also made admissions while you were in the vehicle that you had touched her without her permission, correct?
Correct.
Your Honor, I have nothing. I'm satisfied.
Hold it, but did he say that at the time he thought he had her permission?
At the time of this argument, and at the time that you had contact with her in which you pinched her, did you believe or did you know that you did not have permission to pinch her at that specific time that you had touched her and pinched her? You did not have her permission. Is it correct or not? To pinch her. Okay, Your Honor, I'm satisfied.
Okay, well, and when the police trooper showed up, correct? The police showed up? What happened with your interaction with the police?
Should I describe everything or?
Your Honor, I have one.
Yes, please.
Thank you. On that date, you had encounters with a police officer, Jones, correct?
Correct,
And also another police officer, a trooper, actually Nathan Dillon.
Yes.
Okay, and at some point in time, when the police had come to the home due to the fight that you and your wife had been having, did the police at some point in time tell you to come with them?
Yes.
Okay, and did the police also at some point in time attempt to put cuffs under your
Yes.
back? Okay, so during that process of while the police were investigating this issue with you and your wife, did you walk away?
No.
Okay, did you in any way, shape, or form oppose the police at any point in time during their interaction with you? Did you fail to obey their lawful commands of either stopping, basically not moving away from their area?
Yes, I think yes.
Okay, you can't think, either you did or you didn't.
Yes.
Okay,
Well-
and so in a way, did you also, and not in a way, but did you oppose any of their lawful commands, such as, again, did they indicate for you to stop? And did they say, stop, 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 and you kept moving at some point in time during this interaction with the police?
Yes.
Okay, and you observed them to have a police badge on them, correct?
Correct.
And they were in a blue uniform?
Yes.
Okay, so you were aware that they were they were Michigan State Troopers at that time?
Yes, of course.
Okay, and they were affiliated, they were law enforcement. Your Honor, I'm satisfied.
Well,
Your Honor, the people aren't satisfied.
pardon?
May I voir dire?
Yes.
Mr. Phillip, when the police were trying to arrest you, did you hit one of the officers?
No.
Okay, and are you aware that one of the officers was bleeding from the face? Are you aware that one of the officers was bleeding from the face?
Yes, I was aware, and I even asked him what happened, and he told me he got.
Okay, and so were you thrashing about when they were trying to arrest you? Were you making movements when they were trying to arrest you?
Yes, I guess I.
No, not, did you or did you not? Okay, I don't think we can take this plea, Your
I
Honor.
don't either. I'm ready for an exam.
Okay,
Troopers are still here.
So I admit I didn't know what's happening. I was shocked.
Sir, let me ask you a question. They have ordered you. When the officers were the troopers were trying to arrest you, correct? And during the course of that arrest, did you strike one of the troopers in the face?
So from I remember, I didn't. From I remember. So I wasn't willing to hit anybody. I didn't want to hit anybody. Not my wife, not the troopers.
Okay, initially, I'm not asking whether or not you wanted to. Did you?
Yes, their handcuffs hit the trooper. He even told me that.
Their handcuffs did what?
Due to the struggle, they said due to the struggle, the handcuffs hit.
Okay, so they were trying to put handcuffs on you, right? What, they get one handcuff on you and then you moved away from them?
I had all my hands behind. And I was on the grass, not on the driveway. They put me on the grass.
They put you down.
No, they moved me from the driveway on the grass. They pushed me they took me from the driveway to the grass.
I can't get enough to take a plea, because he's not saying he did it.
I agree, Your Honor.
Your Honor, me personally, I understand we're going to proceed to exam, but I spoke to my client and I was very direct in terms of the the nature of the incident, and he was able to make a factual basis.
Okay, that's fine. He has to tell me that. I have to be convinced that there's a factual basis. He is hedging on any interaction he had with the troopers. So I can't even get let alone a resisting, I can't get an attempted resisting out of what he's telling.
I would like to, because I would like to clear.
Here's what I'll do. I don't have anything else to do. Take him back. I'll let you go back there and talk to him. But I mean, I'm not going to sit up here and try to coerce a plea. But if he doesn't, I'll say it, we can go ahead with the exam. So you can take him back and then you can go back there, Miss White, and talk to him.
Ms. Weidling, I have to go help with a motion in the other courtroom. Will you please? Thank you.
No, send somebody else. What happened? Where, hold it. Where'd the intern go?
She went to go grab the laptop.
Okay. Okay, we are back on the record in the case of the People versus Philippe.
Marie Sincy on behalf of the people.
Okay, good. Sir, you had an adequate opportunity to speak with your attorney?
Yes.
All right. You may continue voir dire, Ms. Vaughn.
Thank you. Okay, so going back to the date of May 20th of 2023, is it fair to say that while you were in the process of being arrested and a trooper with the last name of Jones was attempting to handcuff you, you pulled away at that moment, correct?
Right.
Okay, and due to the struggle that you were having with Trooper Jones's handcuffs struck the left side of his face, causing him to have injuries, suffer injuries, correct?
Correct.
Is that a yes or no?
Yes.
Okay.
Your Honor, the people would be satisfied if that is what actually happened, but it actually struck Trooper Dillon in the face.
I'm just referring
Okay,
to the
you're-
investigator's
all right.
report.
But it struck a trooper in the face. Right?
Yes. But the listed victim is Trooper Dillon. He's the one that suffered injury.
Okay.
Well, let me correct myself. Is it fair to say that it was Trooper Dillon,
Dylan.
who you didn't drive in the scout car with to the jail and the hospital? It was the other trooper that was struck in the face, correct? That you,
Yes.
okay.
All right. Given that testimony, has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 5. Pre-sentence investigation and counts 1, 2, and 4 are dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be
July 6th at 9 a.m. Judge Freshour.
July 6, 2023, 9 a.m. before Judge Freshour. Bond in this matter will continue. Thank you.
Can we address bond?
Sure, go ahead.
Thank you. Okay, so my client, he is 45 years old, and he actually, when he was first arraigned on this matter, he was ordered a personal bond, I believe $50,000 personal bond. From the interim of when he was placed on that bond, he was not 100% understanding of the conditions of what an actual no contact order encompasses. As a result, he did go back to the home where his wife and him live in Saline, Michigan. His wife was not present at that time. However, based on the no contact order, he was violated and his bond actually reverted to
Well,
changed.
hold on a second. That's not really what happened.
I was gonna add more.
Go ahead.
Yes, and there's apparently he had made phone calls to the complainant. And again, I had not been retained on this matter to make sure he was aware of all the conditions what a no contact order encompasses. I've had at least 3 2-hour meetings with Mr. Phillip in the jail, and he is very, very aware of what no contact means, in which he cannot have any telephonic, physical, any type of contact with an individual that a court imposes that order against. So, Your Honor, right, what I'm addressing right now is he is a citizen. He was a citizen of Romania. He came to this country all the way back in 2000
What starts as a lighthearted courtroom quickly shifts into a case with serious consequences. A Michigan defendant appears before the judge ready to accept a plea deal involving domestic violence and attempted resisting and obstructing a police officer. At first, everything seems straightforward. The attorneys explain the agreement. The judge carefully reviews the charges, and everyone appears ready to move forward. But as the court begins questioning the defendant about what actually happened, the atmosphere changes. His answers become hesitant, uncertain, and at times inconsistent. In a guilty plea, the judge must be convinced that the defendant clearly admits the facts supporting each charge. If those facts aren't established, the plea can't simply be accepted. Watch closely, because what happens next shows how every answer in a courtroom can determine whether a case moves forward or comes to a complete stop.
To A, make sure the person appears for all their court hearings. B, does not present a danger to the community or to the complainant. And C, abide by all the contact or any other orders that the court imposes. Now that this was Mr. Phillips' violation in which there was no issues in terms of any contact with the complainant, any violence, anything that would really not be in a position that he should be eligible back to go down to his personal bond status. I believe this is a situation where Mr. Phillip is very aware of the conditions and he will abide by them. He's been in jail for over 35 days, and his parents, I have to make it for a record as an officer of the court, his wife, the complainant, has texted me about 10, 20 times begging me to dismiss this case. I'm not the prosecutor, and wanting Mr. Phillips to come back to see his children, and she mainly see the children, which she has indicated in her text message that the children are very traumatized that they've been away from their father for this amount of time. I handle juvenile matters regularly in Wayne County, and I understand there's issues that can relate to trauma when parents are separated from their children, especially with this length of time. If this man had a prior criminal history, if he was known to be a very violent person, if he was known to be a person that will not appear in court, yes, I believe this would be in a position where you would not be able to budge or change the bond. But he shows no prior history. His profile does not express any indication that he will not comply with all of the orders. I understand what he did in the past, but with my 20+ years of experience, especially working with individuals to make sure they understand conditions that could bring them back into a position that they clearly do not want to be in, I'm requesting you allow him to be released back onto a personal bond, given the fact that I will not say to a court that, oh yes, I believe he's going to comply, when I can't even get my clients to comply with my own understanding of them understanding what's going on with their case. But he is very aware, and he does not under any circumstances want to be back in this situation. So I am requesting, given the fact that he does need to continue the contracts with the jobs that he has, to continue to install floors and also make sure houses are actually continuing with the jobs that he's resurrecting with houses and buildings. So I'm asking that you allow him, given the fact that he's been in jail 30+ days, that he be allowed to be released back on a personal bond.
Bruce Brown?
Your Honor, I don't believe he was ever on a personal cognizance bond. I think he was on a cash surety bond. That's at the beginning, but the reason why the bond was changed, actually this court changed the bond. We've talked about this at numerous times. I have spoken to the victim myself, and while she has told me personally that she thinks that he needs mental health treatment, she also told me that necessarily this case is not inside his personality, but at the time she was in fear for herself and for her children, and had taken her children out of school because of the violations. And not only that, after he was told by the magistrate these conditions, and it's obvious to me that being in this courtroom today and being at PCC handling this case beforehand, if the judge asked him, do you understand that? And he says, yes, it appeared that his understanding. The magistrate went over the no contact order. He chose to break that twice within 48 hours. He just pled to the domestic violence. I don't believe that the changing a bond is appropriate until after PSIR at least, and to see what kind of treatment he needs to get into. I don't believe the conditions have changed. And while I appreciate what Ms. White is saying, I truly don't believe that she can testify, that she can talk to the fact that he wouldn't do this, because he had a prior attorney. Prior attorney and the magistrate told him, do not contact her. I also listened to the defendant's jail calls, the ones that are in English. There are not many. He refers to his wife in every single one of them. While he does not say, I will speak to her or have anyone speak to her, he does talk about her in every single one, which leads me to believe that he also might try to contact her, have these calls not been recorded. So I would ask that the bond to change, remain the same.
Anything else?
Your Honor, belief is different from actual actions and facts that can be actually addressed and looked at as factual observations. There's no beliefs that I believe this court should look at as, if it's a belief, then I know he's going to do it. If he has a track record of coming to the house, banging at the door, calling her, there is no track record of that. I have cases right now that I'm.
So why, when he went in and took a shower in the premises, did he feel a need to text her that he was in the house?
Because he was not aware. He's from Romania. All he mainly talks to me is about Romanian law. But now he's understanding that this is US law. We've talked for at least.
As the questioning continues, the judge focuses on one critical issue: whether the defendant actually resisted the officers during the arrest. Instead of giving direct yes or no answers, the defendant repeatedly hesitates and tries to explain what he was thinking. That creates a legal problem. A guilty plea isn't just about saying I'm guilty. The court must establish a factual basis showing that the defendant's actions meet every element of the offense. When the prosecutor presses further about the struggle with the officers and the injury that occurred, the defendant's uncertainty causes the judge to pause the entire proceeding. Rather than accepting an incomplete plea, the court allows defense counsel another opportunity to speak with the defendant before continuing. It's a reminder that in criminal court, even a single unclear answer can change the direction of an entire hearing.